Welcome back to the channel where I am covering lecture series on company law, and we have already finished the first unit of company law. The video lectures are there on the channel. You can watch those lectures for the introduction to company law and then come back to these lectures, where today I am going to start with unit 2, that is incorporation of the company. So let's start with today's lecture. Procedure of incorporation. The Companies Act of 1956 sets down rules for the establishment of both public and private companies. The most commonly used corporate form is the limited company, unlimited companies being relatively uncommon. A company is formed by registering the memorandum and articles of association with the state registrar of companies of the state in which the main office is to be located. Foreign companies engaged in manufacturing and trading activities abroad are permitted by the Reserve Bank of India to open branch offices in India for the purpose of carrying on the following activities in India. First, to represent the parent company or other foreign companies in various matters in India, for example, acting as buying or selling agents in India, etc. Second, to conduct research work in which the parent company is engaged provided the results of the research work are made available to Indian companies. Third, to undertake export and import or trading activities. Fourth, to promote possible technical and financial collaboration between Indian companies and overseas companies. Application for permission to open a branch, a project office, or liaison office is made via the Reserve Bank of India by submitting Form FNC 5 to the Controller, Foreign Investment and Technology Transfer section of the RBI. For opening a project or site office, application may be made on Form FNC 10 to the Regional Office of the Reserve Bank of India. A foreign investor need not have a local partner whether or not the foreigner wants to hold full equity of the company. The proportion of the equity thus not held by the foreign investor can be offered to the public. Now let's talk about approval of name of the company. The first step in the formation of a company is the approval of the name by the registrar of companies in the state or union territory in which the company will maintain its registered office. This approval is provided subject to certain conditions. For instance, there should not be an existing company by the same name. Further, the last words in the name are required to be private limited in the case of a private company and limited in the case of a public company. The application should mention at least 4 suitable names of the proposed company in order of preference. In the case of a private limited company, the name of the company should end with the words private limited as the last words. In case of a public limited company, the name of the company should end with the word limited as the last word. The ROC generally informs the applicant within 7 days from the date of submission of the application whether or not any of the names applied for is available. Once a name is approved, it is valid for a period of 6 months, within which time memorandum of association and articles of association together with miscellaneous documents should be filed. If one is unable to do so, an application may be made for renewal of name by paying additional fees. After obtaining the name approval, it normally takes approximately 2 to 3 weeks to incorporate a company depending on where the company is registered. Now let's talk about next point, which is memorandum and articles. The MOA and AOA are the most important documents to be submitted to the ROC for the purpose of incorporation of a company. The Memorandum of Association is a document that sets out the constitution of the company. It contains, amongst others, the objectives and the scope of activity of the company, besides also defining the relationship of the company with the outside world. The Articles of Association contain the rules and regulations of the company for the management of its internal affairs, while the memorandum specifies the objectives and purposes for which the company has been formed. The articles lay down the rules and regulations for achieving those objectives and purposes. The ROC will give the certificate of incorporation after the required documents are presented along with the requisite registration fees. which is scaled according to the share capital of the company as stated in its memorandum. A private company can commence business on receipt of its certificate of incorporation. A public company has the option of inviting the public for subscription to its share capital. Accordingly, the company has to issue a prospectus, which provides information about the company to potential investors. The Companies Act specifies the information to be contained in the prospectus. The prospectus has to be filed with the ROC before it can be issued to the public. In case the company decides not to approach the public for the necessary capital and obtains it privately, it can file a statement in lieu of prospectus with the ROC. On fulfillment of these requirements, the ROC issues a certificate of commencement of business to the public company. The company can commence business immediately after it receives this certificate. Now let's talk about next point, which is miscellaneous document. The documents or forms stated are filed along with the MOA and articles of association on payment of filing fees, depending on the authorized capital of the company. First, declaration of compliance duly stamped. Second, notice of the situation of the registered office of the company. Third, particulars of directors, manager, or secretary. Fourth, authority executed on a non-judicial stamp paper in favor of one of the subscribers to the memorandum of association or any other person authorizing him to file the documents and papers for registration and to make necessary corrections if any. Last, the ROC's letter in original indicating the availability of the name. Next point, tax registration. Businesses liable for income tax must obtain a tax identification card and number, which is known as permanent account number, from the Revenue Department. In addition to this, businesses liable to withhold tax must necessarily obtain a tax deduction account number, which is TAN. Both the PAN and the TAN must be indicated on all the returns, documents, and correspondence filed with the Revenue Department. The PAN is also required to be stated in various other documents, such as the documents pertaining to sale or purchase of any immovable property exceeding Rs 5 lakh, sale or purchase of a motor vehicle, time deposit exceeding Rs 5 lakh, contract for sale or purchase of securities exceeding Rs 10 lakh, to name a few. Next point, rules applicable. Companies of Central Government's General Rules and Forms 1956. Filing, registering or approving authority. One copy has to be submitted along with a forwarding letter addressed to the concerned registrar of the companies. Next point, enclosures. The declaration must be submitted with the following annexure. First one, document evidencing payment of fee. Second, memorandum and articles of association. Third, copy of agreement, if any, which the proposed company wishes to enter into with any individual for appointment as its managing or full-time director or manager. Fourth, Form 18. Fifth, Form 32, except for Section 25 company. Next, Form 29, only in case of public companies. Next, power of attorney from subscribers. Letter from registrar of companies making names available. No objection letters from directors or promoters. Requisite fees either in cash or demand draft. Now let's talk about the fees applicable. Fee payable depends on the nominal capital of the company to be registered and may be paid in one of the following modes: cash or postal order up to Rs 501. Demand draft favoring registrar of companies or treasury challan should be payable into specified branches of certain banks. Next point is time limit. It should be submitted before incorporation or within 6 months of the name being made available. Next point is requirements. The declaration has to be signed by an advocate of Supreme Court or High Court or an attorney or pleader entitled to appear before High Court or a secretary or chartered accountant in full-time practice in India who is engaged in the formation of the proposed company or person named in the articles as director manager, or secretary. The registrar of companies has to be satisfied that not only the requirements of section 33 clause 1 and clause 2 have been complied with, but be also satisfied that provisions relating to number of subscribers, lawful nature of objects, and name are complied with. The registrar will check whether the documents have been duly stamped and also whether the documents of other laws are met. Any defect in any of the documents filed has to be rectified either by all the subscribers or their attorney, or by any one subscriber holding the power of attorney on behalf of other subscribers. This form is to be presented to the registrar of companies within 3 months from the date of letter of registrar allowing the name. The declaration is to be given on a non-judicial stamp paper of the requisite value. The stamp paper should be purchased in the name of the person signing the declaration. This declaration is to be given by all the companies at the time of registration, public or private. The place of registration number of the company should be filed up by the mentioning new company therein. The registrar of companies will now accept computer laser printed documents for purposes of registration, provided the documents are neatly and legibly printed and comply with other requirements of the Act. This will be an additional option available to the public to use laser print besides offset printing for submitting the memorandum and articles for the registration of companies. Where the executants of a memorandum of association is illiterate, he shall give his thumb impression or marks, which should be described as such by the subscriber or person writing for him. An agent may sign a memorandum on behalf of a subscriber if he is authorized by a power of attorney to do so. In the case of an illiterate subscriber to the memorandum and articles of association, the thumb impression or mark, duly attested by the person writing for him, should be given. The person attesting the thumb mark should make an endorsement on the document to the effect that it has been read and explained to the subscriber. The registrar of companies will not accept Xerox copies of the memorandum and articles of association for the purposes of registration of companies. This declaration is to be presented by the person signing the declaration or by his bearer at the counter of registrar of companies office. Now let's talk about the managerial remuneration. First point, any person in order to be appointed as the managing director of the company should be a resident of India. Any person being a non-resident in India must obtain an employment visa from the concerned Indian mission abroad at the time of their appointment as the managing director. Second, whereas private companies are free to pay any remuneration to its directors, public companies can remunerate their directors only within the specified limit. Third, in case of public companies, in the event of absence or inadequacy of net profits in any financial year, managerial remuneration is limited to amounts varying from Rs 75,000 to Rs 2 lakh per month, depending on the effective capital of the company. In case of an expatriate managerial person, perquisites in the form of children's education allowance, holiday passage money, and leave travel concession provided to him would not form part of the said ceiling of remuneration. Last point, in case of a managerial position in two companies, remuneration can be drawn from one or both companies provided that the total remuneration drawn from the companies does not exceed the higher maximum limit admissible from any one of the companies of which he is a managerial person. With whom to be filed? The question rises, where should it to be filed? It is to be filed with the registrar of companies or state in which the company is to be registered. And the documents required to be submitted: a printed copy each of the memorandum and articles of association of the proposed company, filed along with the declaration duly stamped with the requisite value of adhesive stamps from the state or union territory treasury, such as below the subscription clause. The subscribers to the memorandum should write in his own handwriting his full name and father's or husband's full name in block letters, full address, occupation, that is, example, business executive, engineer, housewife, etc., and number of equity shares taken, and then put his or her signatures in the column meant for signature. Similarly, at the end of the Articles of Association, the subscriber should write in his own handwriting his full name and father's full name in block letters, full address, occupation. The signatures of the subscribers to the memorandum and article of association should be witnessed by one person, preferably by the person representing the subscribers for registration of the proposed company before the registrar of companies. Under column total number of equity shares, write the total number of the shares taken by the subscribers. Second point, with the stamped copy, one spare copy each of the memorandum and articles of association of the proposed company. Original copy of the letter of the registrar of companies intimating the availability of name. Next point, form number 18, situation of registered office of the company. Fifth, form number 29, consent to act as a director, etc. Dates on the consent form and the undertaking letter should be the same as is mentioned in the memorandum of association signed by the director himself. A private company and the wholly owned government company are not required to file form number 29. Form number 32 in duplicate, particulars of proposed directors, manager or secretary. Next point, power of attorney duly typed on a non-judicial stamp paper of the requisite value. The stamp paper should be purchased in the name of the person signing the authority. Next point, no objection letter from the persons whose name has been given in application for availability of name in form number 1A as promoters or directors but are not interested at a later stage should be obtained, filed with the registrar at the time of submitting documents for registration. Last point, the agreements, if any, which the company proposes to enter with any individual for appointment as managing or full-time director or manager are also to be filed. Fee payable. Cash or a bank draft or pay order treasury challan should be drawn in the name of ROC or the state in which the company is proposed to be registered as per Schedule 10. Now let's talk about the reporting documents. Under this, first one is annual accounts. The Indian company law does not prescribe the books of accounts required to be maintained by a company. It, however, provides that the same should be kept on accrual basis and according to the double entry system of accounting and should be such as may be necessary to give a true and fair state of affairs of the company. The Indian company law requires every company to maintain proper books of account with respect to the following: all sums of money received and expended and the matters in respect of which the receipt and expenditure took place. Second, all sales and purchases of goods by the company. Third, the assets and liabilities of the company. Fourth, in case of companies engaged in manufacturing, processing, mining, etc., such particulars relating to utilization of material or labor or other items of cost. The first annual accounts of a newly incorporated company should be drawn from the date of its incorporation up to the date not preceding the AGM date by more than 9 months. Thereafter, the accounts should be drawn from date of last account up to the day not preceding the AGM date by more than 6 months, subject to the extension of the time limit in certain cases. The accounts of the company must relate to a financial year comprising of 12 months but must not exceed 15 months. The company can obtain an extension of the counting period to the extent of 18 months by seeking a prior permission from the ROC. The annual accounts must be filed with the ROC within 30 days from the date on which the annual general meeting of the company was held or where the AGM is not held, then within 30 days of the last date on which the AGM was required to be held. Second, books of accounts to be kept by the company. Every company is required to maintain proper books of account with respect to all sums of money received and expended, all sales and purchases of goods, the assets and liabilities. Central government may also specifically require the maintenance of certain additional particulars with respect to certain classes of companies. The books of account relating to 8 years immediately preceding the current year, together with supporting vouchers, are required to be preserved in good order. Every profit and loss account and balance sheet of the company, together referred to as financial statements, is required to comply with the accounting standards issued by the Institute of Chartered Accountants of India. Any deviations from the accounting standards, including the reasons and consequent financial effect, is required to be disclosed in the financial statements. The responsibility for the preparation of financial statements on a going concern basis is that of the management. The management is also responsible for selection and consistent application of appropriate accounting policies, including implementation of applicable accounting standards, along with proper explanation relating to any material departures from those accounting standards. The management is also responsible for making judgments and estimates that are reasonable and prudent so as to give a true and fair view of the state of affairs of the entity at the end of the financial year and of the profit or loss of the entity for that period. Next is annual return. Every company having a share capital is required to file an annual return with the registrar of companies within 60 days from the date on which the AGM of the company was held or where the AGM is not held, then within 60 days of the last date on which the AGM was required to be held. Now let's talk about certain accounting related issues. Under this, the first is depreciation. The company law in India permits the use of depreciation rates according to the nature of the classes of assets. Assets can be depreciated either on the basis of straight line method, which is based on the estimated life of the asset, or on the basis of reducing balance method. The law prescribes the minimum rates of depreciation. A company may, however, provide for a higher rate of depreciation based on a bona fide technological evaluation of the asset. Adequate disclosure in the annual accounts must be made in this regard. Next up is dividend. There is no limit on the rate of dividend, but there are certain conditions prescribed with regard to competition of profits that can be distributed as dividend. Generally, no dividend can be paid for any financial year except out of the profits of that year after making an adequate provision for depreciation subject to certain conditions. Dividends may also be distributed out of accumulated profits. Next up is repatriation of profits. A company has to retain a maximum of 10% of the profits as reserves before the declaration of dividends. These reserves, inter alia, can be subsequently converted into equity by way of issue of bonus shares. Dividends are freely repatriable once the investment approval is granted. Next up is imposition of taxes. Currently, domestic companies are taxable at the rate of 35.875% on its taxable income. However, in the case where the income tax liability of the company under the provisions of the domestic tax law works out to less than 7.5% of the book profits derived after making the necessary adjustments, a minimum alternate tax of 7.6875% on the book profits would be payable. Companies are required to withhold tax under the domestic law from certain payments, including salaries paid to employees, interest, professional fee, payments to contractors, commission, winnings from games or lottery or horse races, etc. Moreover, taxes have to be withheld from all payments made to non-residents at the lower of rates specified under the domestic law or under the applicable tax treaty, if any. Next up is the penalty. Under this, imprisonment up to 2 years and fine. Second, person liable for default. Third, person signing the declaration. Now let's talk about certificate of incorporation. After the duly stamped memorandum of association and articles of association, documents and forms are filed and the filing fees are paid. The ROC scrutinizes the documents and, if necessary, instructs the authorized person to make necessary corrections. Thereafter, a certificate of incorporation is issued by the ROC, from which date the company comes into existence. It takes 1 to 2 weeks from the date of filing of MOA and Article of Association to receive a certificate of incorporation. Although a private company can commence business immediately after receiving the certificate of incorporation, a public company cannot do so until it obtains a certificate of commencement of business from the ROC. So that was all about today's lecture, where I covered the procedure of incorporation of a company under company law. Thanks for watching this video lecture, and to keep watching such lectures, do subscribe to this channel and hit the bell icon to be notified every time when I put a video lecture. Thank you.